Y'all's photos look great, Dawn,
Oh,
Ron.
it helps to be a younger version of yourself, isn't it?
So true. I'm never getting rid of mine. It's going to be my obituary picture.
Hey, Don, are you going to address the question if the addendum is not attached and there are some transfer fees that are there, how those fees are addressed?
Be happy to. I have a joke about that, but yes.
I'll tee you up then. I'll tee you up.
Okay.
3 minutes. Elizabeth, do you have a question? I see your hand is raised. If you have a question, you can put it in the chat box, a direct message, or to the panelist. All right, we have 102.
Cindy, before you get started, I was just going to remind everybody that this is a webinar format, so you won't be, we won't be able to hear you. as participants, but if you do have questions, put them in the chat, as Cindy mentioned.
Okay,
Thank
we're going to
you.
go ahead and get started. We have 105, I think, that's on the webinar. So welcome, everyone. I'd like to introduce myself today. My name is Cindy Heyman. I am past chairman of HAR. I'm on the current board of directors for HRIS, and I'm the chair of risk management. And today our webinar is understanding the new HOA addendum changes. As with anything that changes, there's always going to be questions that need to be answered. Hopefully today we'll provide you with all the insight as to not only what has changed, but why these changes have taken place and how they can affect your buyer or seller in a transaction. Today, I'm excited that we have two amazing guest speakers, Dawn Moore and Ron White. Before I pass the virtual microphone off to our experts, I'd like to remind you of the questions, that if you have questions, to please put them in the chat box. You can choose the questions to go directly to either Ron or Dawn or to everyone, but all questions will be fielded and addressed as time permits. And since I know you will ask, is this webinar being recorded? It is. And we will also be sending it out to everyone who signed up. You can also see the online webinar at HAR TV YouTube channel, and that's www.har.com/HARTV. So let me introduce you to our speakers. First, we have Dawn Moore. Dawn has been a leader in the Texas legal and business community for over 37 years. Moore is a founder and chief executive officer of Allegiance Title. Moore has served the real estate and title industry in various capacities. She was one of 6 lawyers appointed to the State Bar of Texas, by the State Bar of Texas, to the Texas Real Estate Commission's Broker Lawyer Committee, which is responsible for writing the residential purchase and sales contracts used by real estate licensees holders statewide. She served in the position for 12 years and also served on the board of the Texas Land Title Association for several years and as president through 2014 and 2015. Moore holds a Bachelor of Science degree in economics, graduating magna cum laude, and a JD degree from Southern Methodist University. So welcome, Dawn. Ron Walker is currently serving as co-chair of the Broker Lawyer Committee for the Texas Real Estate Commission. Ron's experience includes a vast amount of leadership roles for both TREC and for the Texas Association of Realtors. Formerly, he served as Director of Enforcement for the Texas Real Estate Commission and as General Counsel for the Texas Association of Realtors. Ron earned his undergraduate degree in finance at Texas A&M University and completed his law degree with the South College of Law. Again, thank you for joining us, and I will now pass it over to Dawn and Ron.
Thank you for those introductions, Cindy, and it's good to see everyone sort of, at least in spirit here, as we're speaking about these issues. And first of all, let me, of course, let you guys know that Dawn Moore is the real expert here in this particular field. And I say that to give her a hard time because she's so modest, but at the same time, it's absolutely true. If there is an expert in Texas, I think, dealing with the closings of transactions and the issues and the problems that come up related to HOA fees and those type of things, Dawn is the go-to person. So she's going to be ideally qualified to address, I think, the vast majority of your questions. I have the easy part. I get to walk you through the form and then turn it over to Dawn, and she has a number of questions that she's addressed over the years, and I'm sure she'll be able to supplement that time also with the questions that you ask. So initially, we've been dealing with the HOA form for approximately 20 years, maybe a little bit longer, and connected with the what we affectionately call the HOA form is the 2.007 of the, I'm sorry, 2.207.003, 207, chapter 207 of the property code. It's not a very long chapter. You can take a quick look at it, but it governs this whole situation dealing with subdivision information being obtained from an HOA. And of course, it doesn't apply to condos. Well, here we're talking simply about subdivision tracts or subdivision property, single family residences for the most part. So with that, I'm going to ask Teresa to pop up the addendum for property subject to mandatory membership in a property zone association and walk you through those provisions of the form. And it really hasn't, the last changes were very minimal to the form. So I think it's a good time to be able to kind of refamiliarize ourselves with the aspects of the form if you're not already familiar with them. But you'll notice in paragraph A, the very first sentence there essentially references chapter 207 of the property code and defines what we mean by subdivision information, which is essentially tracking the statute very closely. And really what we're talking about is the restrictions, the resale certificate, and all of those attachments that we normally see in the resale certificate. And what the form is designed to do is to provide a mechanism and times by which someone is going to go and ask for that information from the HOA, and then be able to pay for that information, who's going to pay for it, and then a time period in which to deliver it. I should also point out to you up front that this form is technically not mandatory and doesn't have to be attached to every single transaction. In fact, I've negotiated a number of transactions in the past or worked in a number of transactions in the past where the property was subject to a mandatory property owner association, but this form was not attached. Now, with that said, for most real estate brokers and agents, the general consensus is that you should encourage your parties to look at this and to provide it because it deals with issues such as fees and deposits, even if the subdivision information is not that critical to a particular buyer or seller. But the information is valuable, and the form can help avoid some disputes that will arise or potentially arise if the form is not attached. So again, while it's not mandatory, it is, I think, generally encouraged for brokers to discuss it and provide it to their clients as an alternative. So in paragraph A, essentially you have there 4 choices in which to address how the delivery of that information is going to be provided. I'll drop down and take these in somewhat of a reverse order. If you look at paragraph A4, that's the situation where the buyer is simply not requiring the delivery of the information, or that they agree that the buyer doesn't have to provide the information. Now, many people will tell you that as you take a listing, it's very prudent to see about obtaining the subdivision information, perhaps at the time that you take the listing or shortly thereafter, so that you can look at it and perhaps even educate yourself with regard to the seller's perspective about what the fees are going to be and if there's any transfer fees associated with the sale of the property. It contains valuable information. Additionally, by obtaining that early, it's very possible that you can simply provide that information on to the buyer and check box 4, perhaps if the buyer has an opportunity to look at it even before making an offer, and then he doesn't require the delivery of the information thereafter. Now, box 3 addresses the situation where the information has already been provided to the buyer in an example like I just gave, but the resale certificate or the subdivision information may be dated a little bit. Now, the statute doesn't say that the resale certificate has to be of a certain age. Technically, someone could give a 2 or 3 year old resale certificate and subdivision information to a buyer, and that might satisfy him. But the statute does provide that if I want an update to a resale certificate, then that update cannot be older than 6 months. So the HOA is only going to update resale certificates for that are less than 6 months old. And so if that's the case, we might have a subdivision information and resale certificates that's dated, say, 5 months ago. And as a buyer, I may say, well, it's a little bit dated. I would like an update, and perhaps save a little bit of money that way with regard to having to pay the entire fee that the HOA may charge for obtaining the subdivision information otherwise. So box 3 can be handy in that situation. Now, with box 3 and 4 sort of pushed out of the way real quickly, I will say that under box A1, That is, and I think Don would agree with me, the box that we see most commonly checked in most transactions where buyers are making an offer, and of course, where they have not yet had an opportunity to look at the subdivision information. Now, box 2, A2, provides that the buyer is going to request that information and actually obtain that information, pay for it, and deliver it. So under either 1 or 2, notice that 3 things are happening. One of the parties is going to obtain, pay for, and deliver to the other party the defined subdivision information. And then the buyer is going to have an opportunity, once he receives it, to look at it, namely 3 days. And within that 3-day period, he'll have the right to terminate the contract if he doesn't like what he sees. And so those are the effects of 1 and 2. Now, under box 1, the seller has a little more control in terms of when someone is applying for that information and when it's going to be delivered and paying for it as well. Whereas under number 2, the buyer has that ability to decide when he's going to obtain that information and when he's going to deliver it. So there's been some discussion under both 1 and 2 before that by giving the buyer the right to terminate, are we giving him another option, or so to speak? Well, we won't call it an option. We'll simply call it a right to terminate for diligence reasons. In other words, he's doing his due diligence. He's looking at this information now, and he's making a decision whether he wants to go forward in the transaction or not. Now, under box 1, if the seller is able to get that information on the first day after the effective date of the contract, and surprisingly enough, I've noticed a few HOAs moving much faster these days than in the past, then he can immediately or very quickly deliver that over to the buyer and shorten that time period down by which the buyer would normally have the right to terminate. So if I'm going to say insert 10 days into box A1 and 10 days into box A2, depending on which box we check, as under A1, I can shorten that time period by getting that information more quickly and delivering it to the buyer. And then that 3-day period starts kicking from that date forward. Whereas under A2, the buyer may decide that he's going to wait the full 10 days before delivering it over to the seller, and thereby have a total of 13 days in which to terminate the contract. So those are important timeframes to look at. Again, money will come into play, as well as whether or not you have already obtained that information or not. You'll notice in the bold below at the bottom of box A, there's an authorization there for the title companies to obtain the information on behalf of the parties. And many times the title companies, of course, have undertaken that responsibility to request the information and can usually do that very quickly. Of course, they are then passing the charge on to either buyer or seller, depending on who's paying for it. In transactions that I've been involved in, many of you probably recognize this as well. Many of the HOAs, if they're professionally managed, have credit card pages in which you simply can be directed, pay for the credit, pay right there on the first day that you requested pay the fee to obtain the subdivision information, and then it's paid for immediately. Now you're just waiting on it to be delivered. I've noticed in there they charge expedited fees and all sorts of other fees. The last one that I saw had 3 choices for you. You could get it that day immediately. That was the highest price. You could sort of have the medium one, and then you had the longer version, which took the full 10 days. I took the longer one, but in that transaction, I got it back the same day. So I didn't know why I would have paid the expedited fee, but who knows. Box B is there. It's rarely invoked. I've never seen it invoked in a transaction I've worked, but it's there as a safeguard in case there's a material change in the subdivision information that after it's delivered from the time you get to closing, if the seller receives any notices of material changes in that subdivision information, then that gives the buyer the opportunity to review that and potentially terminate. So it's a safeguard there in case you have material changes. But again, like I said, I think it's not very often that would be invoked. And like I said, I've never seen it in any transaction that I've worked. Now, box C is the paragraph that was changed in the last round of this form and deals with the problem in which what kind of fees are considered transfer fees. And I don't have to tell you, but the HOAs are very creative in naming fees. You have the account opening fee, you have the account preparation fee, you have the transfer fee, you have the welcome fee, you have all these different fees that are out there. And on top of that, you have items that are sometimes classified as reserves, and then other types of charges. And sometimes these charges can be misnomers for themselves. From an accounting standpoint, these terms have certain kinds of meanings, but from a marketing standpoint or how the HOA classifies them, they may use these terms not in the correct accounting way. So it becomes a little confusing, and I'm going to leave that for Dawn to address with you because I think that's where many of these issues pop up. But the Broker Lawyer Committee, in trying to wrestle with how do you define these fees and do you come up with definitions, finally said, well, the easiest approach is to simply say all fees that are associated with the transfer, associated with the conveyance, that the HOA is going to charge in order for this property to be transferred from seller to buyer are going to be included now in this box, except for those, of course, that are identified in paragraphs A or D in this addendum. And then now that gets into the question is, can we look at each fee there and decide how to, instead of trying to how to classify it, just say, is this a transfer fee or is this a periodic assessment? So that was the hope that would take place. I think there were some good strides taken there. I still think there's probably a couple holes that Don will probably talk about. As with any form, you try to perfect it over the years as you make the changes. And then finally, paragraph D is really an authorization that's helpful, I think, for the title companies, perhaps when the HOA information is not delivered. So for example, if you check box A4, but the title company still is going to need some certification from the HOA as to the payment of the fees if they're current and if there's some other issues there. And then the title company can get that type of certification directly from the HOA. We have that authorization. Or perhaps if the information is a little bit old now and the title company determines that it has to get an update in that regard, it may be requesting that information. And then there you just have the general notice there to the buyer regarding the repairs. So that is the real quick run through, and I wanted to do that quickly with you and then turn the program over to Dawn. I'm going to tee her up with 2 questions that I know that she's going to want to address with you.
So unfair, Ron.
Well, let's consider them softballs for you. I know they're easy enough for you. One is the question about if this addendum is not attached in a transaction, how are the transfer fees addressed and who pays for them? The second question I have for you is one that seems to be coming up regularly with regard to the change that was made in paragraph C, and that is if the association says we charge at the time of closing 3 months, for example, of monthly dues, and we require the buyer or the seller to pay that at the time of closing, is that a periodic assessment and therefore would not be a transfer fee under C, or is that in fact a transfer fee? So I'll let you take it from here, Dawn. Thank you.
Thank you, Ron.
Such softballs, Ron. Way to go. And you kind of ruined my moment, if you will, because Ron says I am the guru. It's more because I'm passionate about what has happened as a result. This is an unintended consequence of a law that was passed to help title companies get the transaction closed when we had mandatory dues to homeowners associations. So before I get to my passionate comment, I'm going to answer Ron's questions. First off, if this addendum is not attached, because Ron made it very clear that this doesn't need to be attached. The only required notice that a seller give to a buyer is already covered in paragraph 6E2 of your contract. That is the statutory notice that says that the seller has to give to a buyer before they execute the contract. If the seller doesn't give that notice, then the buyer has 7 days after they discover this or get the notice to terminate the contract for any reason. Broker lawyer committee put that notice in the contract. If you read that, that's the statutory language, and then at the very bottom of that paragraph, or a couple of paragraphs that are in there, it says if the parties are concerned about these matters, the TREC addendum should be used. So this addendum is not mandatory. But I tell everybody when I give them that, if you go back to your office and you tell your broker manager that Dawn Moore said you didn't have to have it, I'd shoot you. But the other problem is if you don't attach the HOA addendum, then you don't cover transfer fees. So this is where Ron was saying, so how do you charge transfer fees? And I'm using that term loosely. It really should be considered fees associated with the transfer, but let's call it transfer fees for this purpose. How do you charge that? Well, there isn't anything in the contract for that. So I will tell you, in my baby closing years, my brain thought, well, that should be a seller fee because he pays for preparation of the warranty deed to transfer the property. So in my pea brain, I was thinking the seller should pay for it. When I walked into one of my managers one day and I said, what do you do with these transfer fees? And she said, oh, that's easy, Dawn. I always put it on the buyer's side because they close first. And if they refuse to pay for it, I just move it to the seller's side. Bottom line, I don't have a legal answer of what happens with the transfer fees. These would come under the paragraph of the contract that says if there's any fees that have not already been agreed to in the contract and neither party agrees to pay for it, then the contract can terminate. Okay, there is a provision in the contract for that. So you would have a hole that would allow either party to get out if neither party agreed to pay these fees. Okay. Then the second question that Ron answered, and then I'm going to give you a best practice so you can avoid this question in the future. But we have had these deposits for reserves, if you will, and they didn't necessarily call it that, but the deposits for reserves originally were to cover those kind of accounts that were set up for future use, if you will, for fixing something in the homeowners or whatever. And sometimes they called it capital accounts. Sometimes they call it working reserve. Sometimes they call it a deposit for reserve. And that was for future work. Under the prior addendum, before this change, those were just flat out buyer's fees. But once again, they weren't a defined term. And as Ron spoke about, the homeowners associations or management companies have a great way of changing names on us, and we couldn't cover everything. The other piece of it is it was just flat out a buyer's expense. How do you protect a buyer from an expense you don't know what it is when you write the contract? So it may be very unfair. It may be too much for the buyer to pay. So the way broker lawyer committee then fixed it, if you will, under this addendum, is they said any fees that are associated with the transfer are going to be first paid by buyer to X and seller pay the remainder. Now that makes the seller pay sometimes an unknown, and you've protected a buyer with a cap where you've got the seller paying an unknown. But in fairness, if anybody's going to pay an unknown, it should be the seller, because the seller is the member of the homeowners association. He should know what these fees are. But as you know, and I know, with the management companies taking over these HOAs, oftentimes they don't know what it is. But we have a tendency to cap the buyer. Here's one of the problems that I've talked to many groups about, this change in this contract that just happened. If you don't understand this change, then when you negotiate like you normally negotiate, most of you put a cap on the buyer at 150, 200, and you have seller pay the remainder. If you are fortunate enough to be representing a seller that you represented as a buyer 3 years ago on the same piece of property, when that seller comes to closing and they show on their closing statement the payment for deposits for reserves, they're going to say to you, the agent, they're going to say, wait a minute, why am I paying these? When I was a buyer, I paid for these. Why am I paying these as a seller? And if you didn't point out that contract change, he's going to be mad at you because this was a contract change. Now, I will tell you, the way the contract is interpreted from my viewpoint is any fee that but for the transfer would not be charged is in this paragraph. And therefore, if it's a deposit for reserves, if it's not prepaid, meaning if it's not 2 months prepaid where they don't have to make the next 2 months, they just got it prepaid. If it's a deposit for reserves, it's a capital account. It's all part of this one paragraph where you've capped the buyer and seller pays the remainder. One of the problems that your title company gets is we get the bill from the homeowners association and they divide the fees as they deem it should be paid. I don't care. The title company needs to follow the contract. It doesn't matter when we pay the homeowners association from whom that money came. It's just they want this money. But they do send bills to title companies that this is to be paid by the seller and this is to be paid by the buyer. And some title companies do follow that. They should not follow that. They should follow the contract. Okay. Did I answer your 2 questions, Ron? Okay. All right. Then, if I may, I'm going to get a little bit passionate about this because, as Ron said, this addendum is not required. Let me tell you, this was an unintended consequence of a statute that got passed because when these homeowners associations, and as Ron said, we've been dealing with it for 20 years. That's when this started happening. We had a situation where we started having these mandatory homeowners associations, single family. We weren't having troubles with condos. Single family that were maintained by homeowners associations, and they created mandatory dues that meant those were liens on the property. And therefore, a title company, to be able to close a transaction, just like always, we have to get a payoff. We have to make sure there aren't any past due liens to be able to ensure a buyer of property free and clear of liens. What happened is these homeowners associations were popping up. At that time, they were maintained by their own homeowners. Everybody would volunteer to be a president of the association at some point in time. And then they started getting inundated with title company requests for a statement of dues. It was a simple 1-page, we just need you to tell me what are the dues and what are the special assessments so I can close this transaction. And we could not get responses from these companies. They just wouldn't respond to us. So we couldn't close it. It's as if I have a mortgage on the property and I can't get a payoff. So we couldn't close it. So a fee attorney who worked for a title company, who was also a legislator, passed this bill that said, homeowners, if you're going to have a homeowners association, you must respond to a title company request, a seller request, or a listing agent request for this statement of dues. And if you don't respond within a certain period of time, when the bill was first passed, it was within 10 days of the first request. And if they didn't respond then, we had to give them a second request of 7 days. If they did not respond, then the title company was entitled by law to close these transactions per an affidavit on the seller, and the liens did not attach to the property. Now, the homeowners association could still go back to the seller for his personal liability on those, but there were no liens on the property. So it gave us a vehicle to go ahead and close the transaction. As it was, the homeowners associations added in, well, if we're going to get a statement of dues, let's also make sure the buyer gets the restrictions and the covenants, and let's make sure they get the bylaws. And then let's add more information, financial information that a title company doesn't need, but we think a buyer should have. So they added a bunch of information and they said, we need to be able to charge a reasonable fee for providing that. So this became a way to make an income. All right. So having said that, this is where this whole statute came from. Now, I recommend you get it, but that's where it came from. With regard to all of this information, this is a, please, if I have some homeowners associations, understand that it's a frustration for us. This is a money-making thing for them. The statute allows the seller, listing agent, or title company to order this information at any time. What I'm having troubles in Houston is requiring a copy of the contract when this gets ordered. The statute does not require me to even have a contract if it's the seller, title company, or listing agent ordering this. Furthermore, they're not entitled to a copy of the contract unless perhaps they have a right of first refusal that says that they're going to buy it on those terms. But that's not what I get with a resale certificate. When I get a resale certificate, all I get notice of is whether it has a right of first refusal or not. It doesn't have a waiver. It doesn't give me the process. It just tells me whether I do. So to order this information, I don't need to provide a contract, but yet they're demanding it. And my biggest problem is that's a disclosure issue. We're a non-disclosure state. We should not have to do that. The homeowners association tell you, yes, I'm entitled to the contract. It's required in the statute. The statute got amended. This statute has been amended over several versions, and you got a new amendment this time. Your association sent out a request alert, as you all are aware of it, and we'll talk a little bit about that. But we got an amendment to this that the buyer could also order this, but only in that provision. If a buyer can order the subdivision information, at that time, the homeowners association could request evidence of the buyer's right to order it. Doesn't mean it's a contract, just some evidence. And why not an affidavit? Anyway, I have been pushing back on the homeowners association because I think it's a disclosure issue. And remember, it's not the association. These are these big management companies that are gathering a lot of data on these properties if we release these contracts to them. They're not entitled to it. Secondly, when they tell you they need a buyer's name, and this is my biggest frustration, that's so that they can put on the information a buyer's name. But you have to understand that this information that you get is, I equate it to a seller's disclosure notice. It has nothing to do with who the buyer is. It's a statement of condition of the homeowners association at the time you request this. Has no difference who the buyer may be. So they don't need a buyer name on it. But what they do is they send it out with a buyer name on it, so that if your contract falls through tomorrow and you get a new contract, you have to order a new one because no buyer will accept this because it's got another buyer's name. This should be like a seller's disclosure notice. You can provide it to this buyer and this buyer and this buyer. When you go online to order a resale certificate, they will have a buyer field and they'll put they say it's required. What I do when I order it is, if it's from the seller or the title company, it's me ordering it, I'll put the seller's name in there. So it doesn't reflect a buyer that may not end up being my buyer. They may terminate the contract. And therefore, I can use this information again. I don't need to reorder it. Does that make sense? And then if I've got this information, what Ron was talking about, you could check A4. But what I'd rather have you check is A3. I've provided this information to this buyer. Now, I'm going to talk best practices. I recommend, whether you ordered it under a contract that fell through, or you go ahead and order it during your listing period, that you order this information. Remember, a seller, a title company, or a listing agent can order this information at any time. And you provide this information to this buyer and this buyer and this buyer, so that you will check A3 of the addendum. And if you want to share the addendum, you might go ahead and share it again. But A3 is where the buyer's already got the information. If the buyer wants an update, they'll order it. They're going to have to, well, actually the seller will order it, but the buyer will have to pay for it. And it does not give the buyer an out, other than if the buyer has ordered the update but never got it. Okay? Under A1 and A2, the buyers have an out, as Ron expressed it, And as Ron expressed it, it should be based on due diligence of the homeowner's information. But there's no parameters in there. So if your buyer wants to get out because they didn't like the seller's pink tennis shoes, they can use the HOA documents as an excuse. So to me, paragraph A1 is a free option. Buyer doesn't have to pay for it. Seller pays for it, buyer walks. Free. Paragraph number 2 is an option. Just buyer, it's not free. Buyer has to pay for it. So the buyer has a little skin in the game before they get to terminate. Okay? So either one, those are option periods. Number 3 is not an option period. You've given them the information, they've accepted it, or they can order an update. And then where your buyer is protected, either under A1, A2, or A3, is under paragraph B. If there are any material changes in the homeowner's information from the date the buyers received this information to the date of closing, seller has an obligation to notify buyer of that, and buyer has the right to terminate. Material changes is a legal term. Now, of course, it gets to be decided by the courts, but material changes is going to mean more than just a CPI increase of dues. It'll mean maybe some kind of big litigation that the homeowners association is involved in that could create some liability, or maybe a, I'm not going to use it, foundation issues that have come up because of flooding or something like that. Maybe that would be under the material changes. But otherwise, buyer doesn't have an out under number 3. Now, if you've ever had a buyer use 1 as an option period and not pay you the option period under number 5, your seller is not going to be happy, but they can. The buyer's risk using that as an option, just like Ron said, if the seller can get the information within 1 day, the buyer only has 3 days from receipt of the information to get it. To terminate. So that would be a very short option period. But let me do the converse of this. Let me tell you what I see in paragraph 1 and tell you the reason why I see it in paragraph 1. Generally, I see paragraph 1 being used because people don't understand the law. They think they have to provide it for each buyer. They don't think they can order it ahead of time. So they check paragraph 1 and they give yourself 14 to 15 days to get it. And I'll tell you why you do that. But then with 14 or 15 days, you've given your buyer a 17-day, 18-day option period. That is always past your regular 7 or 10-day option period. So I've had buyers waive the option period, negotiate repairs, and then use this as another way out. But the reason you give me 14 or 15 days, and let me explain that to you, is because under the statute, the homeowners association only has a requirement to deliver you the information within 10 business days. If you request this information earlier than 10 business days, then they are so happy to provide it for you, but charge you an expedited fee. Just like Ron talked about, you can pay a higher expedited fee if you want it in 1 day more. But what is so interesting is when you give me a contract with 14 or 15 days for this homeowner's, and you know that 10 business days is when they have to give it to me. Any date that I give them a due date earlier than that 10 business days, they are going to charge me an expedited fee. And if you have 14 or 15 days, you sign the contract on Friday, you give me the contract on Monday, I might know who the homeowners association is on Tuesday. I fill out the form online, I send it to your buyer or seller, whoever is supposed to pay for it, to put in their credit card information, and it gets ordered Tuesday or Wednesday. 10 business days is further out than 14 days. But I'm going to put a due date of the date you require me to put on it. So I always get an expedited fee on there. Okay? Mm-hmm. Now, let me talk best practices as I have, and why I think what you should do, in my opinion, is now that you know about this update feature that Ron talked about, paragraph 3, and now that we are in a market, this only works in our market right now where your listings are going faster than 6 months, if you've got a bad listing, maybe you don't want to order it right away. But if you think your property is going to sell quicker than 6 months, my recommendation, and then I'll tell you 4 reasons why, is to get the information ordered ahead of time. If your seller's already willing to pay for it, get it, go ahead and order it during the listing period. Then you don't have to put a due date that's expedited on there, and you'll get your regular fee. You order this, and then guess what? You give it to this buyer and this buyer and this buyer, and you won't be lulled in to put a buyer's name where they certify it. You'll put the seller's name in there. And then when you get ready to negotiate, guess what? On the resale certificate, the statute says that the homeowners association must tell you what the fees are associated with the transfer. They have to tell you the amount and to whom. And so now I know what these fees are. And I go to paragraph C and I can say, well, wait a minute, deposits for reserves should be a buyer cost. So guess what I put in that top fee? I put the amount of the deposits for reserves for buyer, and seller can pay the remainder, the welcome fee, the post-closing, the pre-closing, whatever fees they charge. You'll know what you're spending and you can negotiate paragraph C. So 2 reasons I want you to get the resale certificate. You don't have to have an expedited deal, and you're going to need to know the transfer fees. The 3rd reason I want you to have the resale certificate ahead of time is because the homeowners association has to disclose to you what violations of restrictions, covenants and restrictions there are. Like your owner had to paint the white picket fence, it needs repainting, or the driveway needs fixing. They have to present that in the resale certificate. So they have to tell you what are violations, current violations. In your seller's disclosure notice, your seller is also supposed to tell you that. Having said that, he may not have received notice of it. He may not get notice of your violations until you order a resale certificate, because that is when the homeowners association then make an inspection of the property and see if there are any violations of that. I argue for that because during your option period, you should be addressing these items for repair, because there's nothing in here that says the seller has to fix it after the fact when he gets the resale certificate, after the fact that he has to paint the fence or fix the cracked driveway. And you're now outside your option period. Now what do you do? So 1, that's another reason why I want you to have that information ahead of time. No expedited fees, you know what your transfer fees, and you know if there are any violations of covenants and restrictions. So with all of that, I have a best practice. I want paragraph 3. In the least, if you didn't order it in the listing period, but you ordered it and this contract falls through, don't reorder it on a new contract. Just give that information to your next buyer and you check paragraph 3. The trick you need to make sure is that the homeowners association does not put your first buyer's name on there, because your second buyer, then it looks like it's certified to that. As Ron said, there really is no date on these things that it goes false. But the way the homeowners association has a tendency to send you these resale certificates, they put on there, this is good for 60 days. That's really a false statement. It makes everybody think I need to order every 60 days. What it really relates to is there's 2 things in the statute. 1, the homeowners association, if I order it today, cannot give me information that is any older than 60 days. So it's their requirement, not my requirement. And secondly, under the statute, if a resale certificate was issued within the last 60 days, they have to give me a copy of it, me, the seller, the owner, if I ask for it. So it's really interesting how it gets misinterpreted and then becomes a nightmare for all of us. So those are the kind of things that I get a little bit passionate about. I will tell you that your association has done a great job of getting some fixes in the statute. In the statute, whether this is good or bad, they have capped and this doesn't take effect until September 1, they have capped the subdivision information fee that you pay to $375. Now, my problem is I need to dig into it and see if that includes expedited fee, because what I see is mostly $350. So now they'll jump to $375, but it caps it, and there was no cap on it, so they could add it. But the expedited fee is as much as $100 on a $350 certificate, even if it's just one day. And as Ron said, he didn't pay the expedited fee, but they can get it in one day. This is not that hard to do. They can get it for you, but they love to charge that fee. So I don't know if that $375 included that expedited fee. But more importantly, and this is great, that paragraph 3, if you've ordered the resale certificate and the subdivision information within the last 6 months, so that you're able to give it to the buyer and not give the buyer a free option, but the buyer wants an update, they've also capped the fee for the update at $75, which is great, because what we were getting when we ordered update from the homeowners association, they charged me the regular fee for the full subdivision information. And once when I called them and said, wait a minute, I just ordered an update on this, I was told that the person who was filling out the resale certificate was an attorney, and that's his billable rate per hour. So the legislature has passed this bill that should be September 1, that's $75. So why wouldn't I, if I was a seller? Now, if I was a buyer, I'd want every out I can get under the contract, right? If I was a buyer, I want an option period all the way to closing. As a seller, you want to take all those outs away from a buyer. So as a seller, I'm always going to order this information during my listing period, provided I think my property is going to sell quickly. I'm going to check 3. And if the buyer wants an update, it's $75. I think it's great. With regard to paragraph D happens if you don't get me a new resale certificate, meaning you either have an older resale certificate or you waived it. I'm going to have to order an update for it from the title company. Maybe if the resale certificate isn't that old, or some homeowners association have semi-annual dues or annual dues, I might not need an update. But if I need an update, I need that box checked under paragraph D. If you check 1 or 2, you do not need to check a box under D. Trick for Houston I'm seeing in MLS, people are putting, you must add the homeowner's information addendum, but you must check box 4 and check buyer will buy the information into paragraph D. Paragraph D was really intended, my buyer doesn't care about the covenants and restrictions or resale certificate, and the title company only needs a statement of dues, like the olden days. I only need the special assessment, statement of dues, that sort of thing. And so paragraph D was to take care of the title company's needs, but the homeowners association is saying, no, this is a way I can collect for more money. I'm going to provide you all of this information. So paragraph D, they charge you that big fee. Interestingly enough, gang, you get the copies of see the subdivision information that you pay for? You get the restrictions and the bylaws from the title company, because the statute requires the homeowners association to file those of record. And those are exception documents that you get from the title company. So you don't have to pay for it to get it from them, which makes me mad because you get it to us for free. Secondly, the statute said that if the homeowners association or management company had a website, they had to post these restrictions and bylaws on their website. So your buyer can get access to that. Trick that the homeowner association did, because I was always suggesting, since you only have 3 days to determine if you like it or not, if you really do due diligence, sometimes these are 600 pages long. A buyer needs to start looking at these right away. Get on their website, start looking at them, reading them right away. But the trick that the homeowners association has done is now to access them on their website. They follow the statute, but to access them on the website, you have to pay to get a password. The new statute that got passed that you guys had to do, I think takes that away from them, that it will be posted to their website. Okay, so yeah, I'm passionate.
Very passionate. This is great.
Sorry.
No, this is great. This is the information we need. We do have a little bit of time, Dawn and Ron, for some questions. Some of these questions may have already been answered, but I'm going to ask them again since we're recording this webinar and it will be uploaded to HAR TV. The first question is, agents are finding that title companies have stopped closings over disputes regarding what fees and reserves, etc., were applicable in Section C of the HOA Addendum. This is an area of clarification that may come up and does indeed need to be commented on today.
Mhm.
Who wants to?
Happy to comment. Ron, did you want to say something? I'm sorry.
No, go ahead.
Okay, happy to comment. Yes, the title company is neutral party. But yes, they are tasked to close per the contract. However, they can't force anybody to close if someone disagrees with their interpretation. Now, what I have seen in a particular example that was sent to me is the title company may have added to the confusion, which is a shame, but the title company, they're not attorneys. They're not there to interpret the contract. And in this particular case, both buyer agent and seller agent interpreted it differently. The title company interpreted it one way. But under this fees and deposits for reserves, these are all the fees associated with the transfer. And so even those capital account fees should have been negotiated or paid per paragraph C. Now, in a particular circumstance that stalled a title company's closing or buyer's closing, if you had called me, Mr. Buyer, I would have said, tell the title company, put those fees on the seller's side, and I'm going to show up at closing. If the seller then didn't close, then he's in default. As it was, because the title company was taking a neutral position in their debate, none of them came to closing. None of them instructed the title company on what to do. And I think everybody was waiting for the title company to make the stand and say, seller, you're wrong, buyer, you're right. That we're not really to do that. We can say, this is how we interpret the contract and put the fees accordingly. In that particular case, the title company should have put that on the seller's side to start with. Maybe they started the confusion. But the homeowners association sent them that bill and told them that these deposits for reserves should be paid by the buyer. But quit listening to the homeowners association. Pay attention to your contract.
Absolutely. Second question is, listing agents are uploading the HOA addendum into the disclosures, and they're automatically checking number 4, buyer does not require. What's your thoughts on this?
That's what I said is from Houston to avoid the auction and avoid having the seller pay for this resale. I personally don't like it. As much as you heard me passionate, and I'm angry how this unintended consequence resulted, I still say the seller should give as much information to the buyer as possible. And so in this situation, the best practice is for seller to provide this information before they execute the contract, just like you would do a seller's disclosure notice, and check 3. So you also don't get frustrated being the good guy. I'm providing you this information, but now you're terminating under 1 or 2 just because I wore pink tennis shoes. I want you to have this information. I want you to take this information so that you're relying on it from a different source, not me. And here's the information, but I don't want to just give you a free walk. So I want your sellers to provide it to them. I do not like the practice of checking paragraph 4 and then relying on paragraph D below.
Okay. Also, there's a question. I received an offer on an HOA addendum. There was no selection in a 1 through 4. What would a title company do if this was blank?
We're going to have to order the statement of dues, if you will, under paragraph D, okay? Because if we don't make the request for the statement of dues, I can't close it because they are liens. If I make a request and then the homeowners association does not respond to me within the required time, then I can close. But I don't have to provide, it's just providing that if the buyers or sellers want to provide this information under 1 A1 through 4. But I need a statement of dues. As it turns out, the homeowners association uses the excuse that they're not going to provide me just that. They're providing me everything to charge the whole thing. But your resale certificate has a whole lot more information than what I even need. I would never recommend a buyer ever checking paragraph 4 unless maybe they lived in a home in the same subdivision governed by the same entity.
Okay, thank you. Next question is HOA A2 states that the buyer is to deliver the docs to the seller. If that does not occur, is the buyer in default?
It's so interesting that brought up, because I hadn't really paid attention to this. And Ron, that's kind of interesting to pay attention to too, because it goes on to say, if buyer obtains the subdivision information within the time required, buyer may terminate the contract within 3 days after buyer receives the subdivision information. So arguably, this is kind of interesting. If the buyer was to order it in 10 days, but didn't provide it to the seller, arguably that could be a default, but what are the damages? But I don't really care. If the buyer received it within 10 days, they only had 3 days from their receipt. So I don't think they could hold off on this and borrow their extra 3 days. But I can see why a seller might want to have this information. So if the buyer terminates under this provision, like they can, he could provide it to the next buyer. Having said that, in my dream world, this would be my dream world because of the way it's working, is I would never have paragraph 1. Ron knows this. I would take out paragraph 1, and paragraph 2 would be my first choice, where the buyer has to pay something. And so they have a little skin in the game if they're going to terminate. But then if it closes, the seller reimburses them for it. That's just kind of my dream world. Having said that, under paragraph 2, the question was, are they in default if they don't provide it to the seller? I guess they are, but I don't know how the court would look at that, if that would give the seller a right to walk away from selling the property to this buyer. And that's what you have to look at right now in this multiple offer market, is where sellers are trying to look for outs under the contract. I think that's in.
I would be of the opinion that it does not constitute a default for which the seller would have the ability to terminate the contract. Now, what it does do is removes the buyer's right to terminate under that paragraph, but I don't think the seller can claim that's a default.
Gotcha.
Okay.
Thank you.
Next question is, would an HOA dues increase be considered as material changes?
I kind of tried to mention that before. I don't think a CPI index increase would be a material change. It'd have to be, material change is a legal term. So it would have to be disputed, but it'd have to be pretty material, not just a regular dues increase.
These are all great questions, and we have a few more. Would the option fee go back to the buyer in the case of terminating during the 3 days without the 10-day option? So do you understand the question?
Well, option fee is never refunded to buyer.
Correct.
So if you're talking earnest money, that's different. Option money is never refunded to the buyer because an option fee is earned the minute you execute the contract. Because from that day one, your buyer has bought themselves freedom. Whether they ever exercise it or not, they bought that right. So that option fee is never due back to the buyer.
Okay. Another question is, does the checking box A4 cover the resale certificate also?
No, as I was talking about, when the title company will need a statement of dues. When I go down, if you waive it, and therefore I don't have a statement of dues otherwise, the resale certificate can work as a statement of dues for the title company, but it's more than what I really need. Under paragraph D is where, if you read that closely, I'm asking for certain information that I have to do to close this transaction. That's all the information I need. Having said that, if the homeowners association won't give me just that information, they make me order the whole thing, I may get a resale certificate under paragraph D when I order the information I need. But that's not necessarily the case in every transaction.
Right, but that's under A4, the buyer is waiving the right to receive the resale certificate. The
Right.
title company, though, still needs documentation. Right.
Fantastic. Fantastic. Next question. If a $3,300 HOA annual, $1,000 water, 639 uplift, 350 transfer, plus capitalization fee of 300, is this the total and placed on the form?
It could be. If they're not prepaid items, but they're fees that are deposits for reserves that everybody pays, it would be where the seller would end up paying that if you cap the buyer at $1,000 at $100. That's why it's so important to get this resale certificate ahead of time. And bear with me, many people say, well, I just call the homeowners association and I can get it verbally. They're not bound to that. They are bound to the resale certificate. So,
Okay. What are your thoughts on inserting half in paragraph C?
Ron, you add that from your legal TREC point of view.
Well, the dollar sign there, of course, if you're talking about technical compliance with TREC rules about what you should be doing, the real estate commission, if a dispute later arises, is going to say, well, hey, you were supposed to insert a dollar amount. So that'd be my first concern. But if you say half, the next is not to exceed, is half of what, right? So that'd be the next question that comes up. So I would tend to caution against it. But if you're assuming that you get back to the same issue about trying to be definite with regard to the fees here. So whereas there could be some lack of being definite with regard to the seller's excess, you do have more definitive information here regarding to the buyer's amount. So I would just put that in there and estimate what that's going to be if you want to get close to half.
Okay. Is there a responsibility on the listing agent to let the buyer know of all the various fees will be charged at closing?
The listing
No.
agent responsibility? No. I mean, that's where I think Don has kind of stressed that the importance of the statute and the whole underlying important part of the intent of the statute and the form is to get information into the buyer's hands so that they know. And as a seller, as Don was pointing out, getting it during your listing period or even before you list the property for sale, you have the information. And so you're now able to make or to negotiate in a better position as opposed to negotiating an unknown. You're now negotiating a known.
Okay. What if the buyer didn't get subdivision information but wanted it later or after they closed on the home? Can they still get it?
Yeah. Then he is a seller, a listing agent, or a title company. As an owner of the property, you can order it at any time. You're going to have to pay for it, but yes, you can order it any time. And that's my frustration. They tell you, well, we need the copy of the contract. You do not have to have a copy of the contract to order this.
Okay. Clarification on the resale certificate. How good is it long for? How many days?
If you've ordered the resale certificate within the last 6 months, you can use paragraph 3 and get this update process, okay? After 6 months, the homeowners association does not have a requirement to update that for you, but it doesn't mean it went false. It's kind of like your seller's disclosure notice. It's a statement of the condition of the property now. It might need updating, but it doesn't go false after a certain period of time. And that's what people don't understand. It's the statement of condition of the property now may need updating, but it doesn't go false after a period of time.
Okay. What's the average fee of HOAs are charging for the information, and what's the typical expenditure fees?
Now it will be $375 because the statute allows it. It has been, in most of the ones I've seen $350. The smaller associations were $175, but they went up to $250, and I've seen them as high as $500. The worst part about it is the expedited fees. They all charge about $100 if you put one day quicker than they need to do it. I had 3 mandatory homeowners associations on one piece of property in Plano, and it took me $1,000 just to order the information I needed to close.
Of course, the second part of that, Don, is the average transfer fees that are associated. I don't think there's any average out there, right?
There is no average. That and the statute, the evolution of the statute is when the legislature said, okay, wait, homeowners association, it was really the management companies, kept adding fees, not even doing it within their homeowners association meeting. They just kept adding fees, and it changed on a daily basis. So the statute that we got involved, the resale certificate had to say it. This new statute is very interesting because the management certificate that's going to be filed, I think this takes place not until January of next year, has to say what the transfer fees are. But if there is a change to it, they have to file it in 30 days. So there's a new statute. I need to look at that more closely, but that will help us as well to keep them from proliferating with transfer fees that got out of hand. And people said, how do we control this? I said, the homeowners are the members of the homeowners association. Those are the only people that can control their management companies from doing this. The problem is they got management companies to run their association for them. They no longer had to serve voluntarily. And there was no dues increase because they made money off of these things. So it was an uphill battle.
Yeah, and you touch on the point where the management companies sometimes will structure sort of these welcome fees or these new account fees that they're just pass-throughs right to the management company. So a lot of times what you're paying up front is management fees.
Okay. If the buyer paid in order to close, is there any recourse to have the buyer credited for expenses after their closing?
Could you repeat that for me?
If buyer paid in order to close, is there any recourse to have the buyer credited for expenses after the closing?
From
I
whom?
guess there was a dispute on the charges and the buyer went ahead and paid.
Okay.
There's no credit. He might have an ability to go back and try to obtain some money, but the deal's closed, so there's no longer anything to credit.
Okay.
I think there was a question, the title company charged the wrong fees. And so do they have the right to go back to the title company? Yes, but remember the title company doesn't assume, and I have to tell people this, when we close a transaction, it is incumbent on the parties to review the settlement statement. We don't assume someone's obligation to pay something. So if we charge it wrong and they sign it, they're just as complicit as we are. We don't assume that fee. But we've had lots of people who say, well, it's Dawn or title company, it's your fault. You should have collected it. You owe me. I don't owe you. Maybe the seller owes you, and I'll be happy to help you. But I'm not really parties. I'm not a party to the contract. I'm the neutral party. And it's kind of like going into the grocery store and giving the clerk a $10 bill and getting change for a 20. You don't just walk out and say they caused the problem. It's you have obligations. And yes, the title company should help you. So don't get me wrong. I'm not trying to say it's not my job. If they charged it wrong, they should help you. But they are not responsible to pick up someone's fees just because they made a mistake on the HUD or the CD. The buyers and sellers are responsible for reviewing that too.
Okay. Would releasing liens automatically be billed to seller, or is it limited in paragraph C as well?
In your closing costs, the sellers will pay for all recording and preparation of release of liens. If there are past due dues that we're going to pay and there's a lien to release, the seller will pay for that.
Okay. In paragraph C, I've seen all fees are on the line. All fees are paid in paragraph C. Is that okay to do?
Ron, that's yours.
They're writing in all?
All.
Well, I guess that's a little better to me, at least, than the word half. But I think that that indicates that I would just simply say that if the seller is going to pay all, you simply insert 0 there for the buyer. If you want the buyer to pay all, then just make that so high that you know you're going to be covered. Put in $5,000 and you'll be okay.
Okay. Dawn, I have a resale certificate for one house today, and I'm listing another house in the same subdivision. am I able to pay the update for the second home?
No.
Okay.
No. The resale certificate is specific to that piece of property as far as, I mean, it may have matching things, but are the dues paid on that piece of property? Have they prepaid any of the special dues? So it has to do with that particular property, but your resale certificate would, and the violations, if there are any violations of covenants and restrictions. So your resale certificate is specific to the property.
Okay. I was told some newer subdivisions have developmental fees. Any tips regarding these fees?
If they are charged because you transfer, and but for the transfer, they're not charged, they're rolled into paragraph C.
Okay. This one says, if an HOA has written that the seller is to pay a certain percentage of the sales price at closing, can the amount be included in paragraph C as a buyer cost, which is what you were just talking about?
Okay, so transfer fees were on property were kind of outlawed unless there's a specific reason. So now you're talking a percentage of a transfer fee. That once again, then if it's legitimate, if they really can do that, because the way you phrased it sounded kind of strange, that would be part of paragraph C again. It'd be fees. You have to look at it. If these fees wouldn't be charged, but for the sale, then they're not part of this. If they're charged because this is selling, and that's the only reason, that's part of paragraph C. It's fees associated with the transfer.
Okay. Any thoughts on special assessments if they are coming in the near future, however, not disclosed on the HOA docs?
Special assessments, if they have been assessed, have to be disclosed on the resale certificate, and they would have to be part of the statement of dues that I would get. Special assessments, even though they say this amount has been paid on the special assessment and the remainder is due every month for this, it's like a mortgage, and the seller is responsible for paying it fully off. I would have to get a full payoff of the special assessment. If they're not assessed, meaning you kind of ask this question as if we know it's coming, but it's not there. If it's not assessed and voted by the homeowner such that it doesn't show on the resale certificate, the buyer is going to be responsible for it.
Okay. And once it, go ahead, Brian.
An ancillary question to that is going to be is, should that be disclosed otherwise in the seller's disclosure notice, which is a whole different question, depending on what's actually known versus what's speculated. So.
Okay. What are legitimate reasons a percentage of sales price would be required to transfer?
What were the exemptions on that, those prohibited transfer fees? It was for education. What? You'd have to go back to that statute, and I don't have it in front of me. I'm sorry.
Okay. All right. Well, that's all the questions in the chat box that hasn't been answered previously. I want to thank Ron and Dawn for joining us today. Do y'all want to have any closing statements?
I just want to say thanks for Dawn. I learn something new every time she speaks, and so it's always good to see her this way.
Well, and I'm always honored to be on a panel with Ron, so ditto, and thank you for inviting us to speak.
Absolutely. This was great information. I know we're going to have a lot more questions. This session was recorded as a webinar. It will be uploaded to HAR TV. We want to thank you both for being here, and I hope everyone has a wonderful day and a wonderful week and weekend. So thank you both.
Thank you.
Thank you.
This concludes our program.